Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault with especially aggravated kidnapping. Also charged with aggravated assault with $500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28th, 2020? 7:44 p.m. How, does the FBI find people? People's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
All right. We are back. We're back. We got... Lunch got spicy. It was unbelievable. All right, I need that quieter. Where's my music? All my buttons are in the wrong spot. Like, I keep reaching. I'm getting a workout reaching for the wrong buttons. There we go. All right, we're back. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you for joining me here in my vacation today. Live from the master bedroom. There's a hole in the wall. Have you guys seen this? Somebody like ripped the phone, I think, out of the wall. So I'm watching it for bugs. No bugs yet. We're good. Welcome back. We are on vacation. We're here live. We have something spicy to bring you. And I got to say, this one comes with a content warning for language. Yeah, no, it's not the Young Thug trial. Great idea, but no, not Young Thug. This is something new and different. This is Judge Cedric Simpson. Why do I hear? My test 1 2 check 1 2. I've got a weird echo. Wow, that's weird. We were stuck in a time loop earlier. Before we do that, though, we have to first properly thank Greeners. Greeners 6 attorney, welcome. First in chat today. Oh, this is nuts. I feel like I'm like a monster truck announcer. There's just that. What am I hearing? Test 1 2 test 1 check. Wow. Test 1 2 test 1 2 test. I guess it's just bouncing off the wall. Oh well. Plug the hole. Mice can get it. It's the mice getting out of the hole I'm more concerned about. They can live in the wall. I don't own the house. All right. That being said, all right, here's what we're going to do. Ready? We're going to Judge Cedric Simpson's court right now because things are happening, and I have to say there's some language here. And Judge Cedric Simpson does not put up with language. Greeners, by the way, thanks for winning the internet. You're first in chat. The internet is all yours, my friend. Keep it running for me. I'm counting on you. Do you notice I moved the camera a little bit? Do you notice I moved the camera? So now it still looks like I'm looking at a bug. I'm just watching the screen. This is it. I'm watching the screen. But maybe if I put it right there instead, it'll look a little better. Let's see if I look like this. I'm looking down. I just need the camera right here. I might move it. I might move the camera. We'll work on that later. All right. That being said, let's go quickly to Judge Cedric Simpson, who was handing out bench warrants because people deserve warrants.
I'd actually it was released Friday the 9th?
Yes.
This will issue August 9th, 2024.
People show up for court. You can save yourself.
People versus Daryl Jarrell.
Daryl, you here? I think Daryl's here.
Ernie is so happy to see you.
I am very happy to see you. Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Jarrell. Please state your name.
Gerald. Okay. And where are we on his case?
Your Honor, we have not had contact prior to today. I think the number we have for you
I don't have a phone.
Oh, no phone.
Whoever gave you a number, it was invalid.
Okay. So
I don't have a phone.
I'll need to figure out a way to get in touch with him so we can go over the case together.
So are there two separate? Got it.
No phone. It's like Mrs. R.A.
If I give you my number.
What is
You have a PO box?
I don't have a phone. I have a line of center. Use a PO box, I think.
Okay. Do you have an email address?
No.
No
I'm under
email.
the radar. Use electronics.
I'm under the radar. I don't use electronics.
So you guys are going to be trying to figure out a way to get to make contact with each other, right? So
Thank you, Alley Cat.
okay, so the reason I say that is let me just do this. Let me give you a little bit of time so that I'm going to turn this out to September 4th, 2024, 9 a.m.
What's the holdup?
What?
It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing.
What do you mean what the holdup is?
This is it's an arraignment, right? Or a preliminary exam?
No. You're not charged with a felony, so it's not a preliminary examination.
Right.
You were arraigned in this on July 24th.
Mhm.
They set this date. Your attorney hasn't been able to talk to you about the cases at all.
Okay.
So I'm trying to I can set it for 2 weeks out.
Yeah,
But the problem,
I'm tired of the state. I'm ready to leave this state as soon as possible. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can kiss my ass. This is
you know what?
It's irrelevant.
No. I'm going to tell you what. You don't come in here. You don't.
Fuck you.
Okay. That's contempt. That's 93. Keep going.
Fuck you.
That's another
Fuck you
93.
again.
That's another 93.
Fucking game.
That's another 93. That's another 93. That's 6 93s consecutive.
Look at this guy. This guy showed up for court. He can't believe it either.
Okay, it's People versus Keith Jenkins. Mr. Jenkins does not want to. He does not want to unmute.
I had a lot to write down on that.
I just seen. How you doing, Your Honor? How you doing, sir? Oh man,
I'm doing great.
Assistant Public Defender
just
Natalie
made $600
Payton on behalf of Mr.
in swear
Jenkins. Mr.
fees.
Jenkins, can you please state your full name for the record?
Yes, Keith Bernard Jenkins Jr.
You're all right, Mr. Jenkins. None of that bothered me. That guy, I don't know what his problem was. Don't worry about it. Jenkins really did not want to hit his. He's like, he wanted to black his screen and pretend like he wasn't here.
I'll take
All
the
right.
bench warrant, please, Judge.
We are just respectfully requesting adjournment in this matter, Your Honor. There is an offer in this file, which I have discussed with Mr. Jenkins. We're just requesting a brief adjournment to look at the video discovery. And I will say also for the record that Mr. Jenkins is obscenely professional whenever I've talked with him. So I don't.
Really?
And Mr. Jenkins was worried, but nothing to worry about, Mr. Jenkins. You're okay.
Okay. Yeah.
Why, he didn't have anything to say to me?
He did not.
Oh, okay. I don't know. People just kept talking to me. It just turns out bad for them. All right. How much time are you guys going to need to try to get through what you got to get through?
Just 2 to 3 weeks, Your Honor.
August 21st, 2024.
Okay. Oh, wait. And one question, if I'm sorry.
Yeah, go ahead.
Because I happen. What I don't want is I would like to be able, like, after everything is clear, would that affect any of my is to be able to get in the field of like law enforcement? Like, would it be on my record? I don't want.
I gotcha. You know what? Hang on a second. I'm going to adjourn it to September. No, hold on. I'm going to adjourn it to September 4th because it sounds like you got to go through the evidence. You got a lot of questions and talk in more detail with your attorney about that. Okay.
Okay.
All right. September 4th, 2024, 9 a.m. Thank you.
Thank you, Your Honor. Thank you, Mr. Jenkins. You can log off now and we'll be in touch, okay?
Yes.
Okay.
Thank you.
Sorry.
All right, take care.
Okay, we're gonna bail on Judge Simpson there for a bit. Wow, that got spicy very quickly. I don't know where was it, Durrell? I think Mr. Durrell. I don't know where he went. I think his window has bars now. I think his window has bars. Am I hearing? Hang on. Test one. There it is. I found my echo. The TV is talking to me. All right. Oh my goodness, that's better. That is better. I cannot believe that. That was nuts. That was absolutely nuts. 6 times he dropped the bomb, directed at the judge, and the judge uses law to handle that, and that's called contempt of court, and contempt of court bears a $93 fine for swearing per offense, and he racked up $600 real quick. Oh my goodness. Okay, we have some reading to do. If I can find it, I don't know where it went. Oh, it's way up there on camera 6. Let's see. We have some reading. Probably no cursey words in this, but Indy Cindy, thanks for the 14 months. Congratulations as well. He went straight to jail, which means he's going to be coming out. There will be a time. That's one of the wonderful things about contempt of court. You don't get a new judge to handle your contempt issue. You get to go back to the same one you had the issue with before. So Judge Simpson, he's going to go home today. He's going to put on, a new fresh purple shirt and go out and have some fancy dinner. Mr. Durrell is going to eat whatever they're serving at the jail. And he will keep eating whatever they're serving in the jail until Judge Simpson puts him on the docket again and brings him back out and says, okay, let's talk. He may have had a change of heart. He might still have the same attitude. 93 times 6. I thought it was, whoa, it's days, not dollars. I thought he was talking money. Hey, Siri. What is 93 times 6? I can only tell you.
93 times 6 is 558.
He was going to leave the state as soon as he could. I have to go back. We have to go back and rewatch this. Oh my goodness. Let's do a quick rewind, shall we? I need to jog. I paused it. This means something completely different. He's not going to get back in front of the judge until after Brian Koberger. This is nuts. Oh my goodness. Okay, scroll fast forward. Why is it going so slowly? Search. There we go. I think it's going faster now. It is. There was our intro. Here we go. Okay, here, judge calls the case. I think we're right here. Let's go to this. We're going to rewatch this really quick.
Case People versus Daryl Jarrell.
Daryl Jarrell walks up from the back of court, carrying his hat in his hand.
Miss Perny is so happy to see you.
I am very happy to see you.
She's not happy anymore.
Defender Lauren Perny on behalf of Mr. Jarrell. Please state your name.
Daryl Jarrell.
Okay. And
this is round 2. We've watched this before, but
Your Honor, we have not had contact prior to today. I think the number we have for you may not.
I don't have a phone. So whoever gave you a number, it was invalid.
Watch this guy right here next to me, okay? Watch
I'll
him.
need to figure out a way to get in touch with him so we can go over the case together.
So are there 2 separate? Got it.
So he doesn't have a phone, doesn't have an email, doesn't have a P.O. box. He doesn't.
I give you my number.
What is?
You have a P.O. box?
I don't have a phone. I have in the center. Use a P.O. box, I think.
Okay. Do you have an email address?
No. I'm on his radar. Use electronics.
You're not under the radar anymore. We know exactly where you are, sir.
So you guys are going to be trying to figure out a way to make contact with each other, right? So
Yeah.
okay, so the reason I say that is let me just do this. Let me give you a little bit of time.
Watch my man right here.
I'm going to turn this out to September 4th, 2024, 9 a.m.
What's the holdup? It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing.
What do you mean what the holdup is?
This is it's an arraignment, right? Or a preliminary exam?
No. You're not charged with a felony, so it's not a preliminary examination.
Right.
You were arraigned in this on July 24th. They set this date. Your attorney hasn't been able to talk to you about the cases at all.
Okay.
So I'm trying to I can set it for 2 weeks out.
Yeah.
But the problem.
I'm tired of the state. I'm ready to leave this state as soon as possible. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can kiss my ass. This is
you know what? No. I'm gonna tell you what. You don't come in here. You don't.
Fuck you.
Okay. That's contempt. That's 93. Keep going.
Fuck you.
That's another
Fuck you
93.
again.
That's another 93.
Fucking game.
That's another 93. That's another 93. That's 6 93s consecutive.
There was days, not dollars. I thought it was a fine. I thought he was putting money in the swear jar. No, he just bought himself room and board.
What's the case? People versus Keith Yankee.
Courtesy of Judge Simpson.
Mr. Jenkins does not want to. He does not.
Yeah, Mr. Jenkins is like, I don't want to follow that. Who wants to follow that? He could have got 7. Judge hit him with 6. I heard 7 as well. So yeah, he nearly got himself 2 years. A solid year and a half in the slammer, thinking up new words to tell the judge. So mark your calendar, 18 months down the road. I know he might get out sooner, but I doubt it. Man. We have in the background here a document that we're looking at reading with each other. We can read this together. This document is not going to have any of the words that you just heard that defendant tell the judge, but it is spicy nonetheless because this goes back to the Alec Baldwin trial. And Baldwin had his case thrown out of court. Oops, there we went. I just faded to black. I think I've got the ability to turn that button off. I think they just gave me that ability. They upgraded the firmware so I can. Nobody uses this button. Okay, just for the heads up, nobody uses the button. Even in TV land, nobody fades to black. It just doesn't happen. They're always cut to the next thing, and they never want the fade out because people turn off. Then they turn off off goes the remote. You don't fade to black. So I don't know why I have it right there on the corner where I can bump it all the time. The light doesn't work on it. I don't want to, I'll tap it. Oh. The red light works, the white light does not. So one more issue on that board. All right, let's see. We have a letter from the judge. This is basically her signing off on this case. I need to put it down here. I'm going to do that. It's in camera 6. Put it down here, but I can't see chat when this happens. But this allows me to sort of look almost forward when I'm reading. Okay, this matter came before the court of defendant Alec Baldwin's expedited motion for dismissal and sanctions under Brady Giglio and Rule 5-501, filed July 11th. The expedited motion, having reviewed the briefing, entertained oral argument, conducted an evidentiary hearing, and otherwise fully advised, the court finds, concludes, and orders that. Here's a procedural summary. This is the background. July 11th, defendant filed an expedited motion. The state did not file a response. July 12th, the court entertained oral argument by the parties. In addition, the court conducted an evidentiary hearing in furtherance of resolving defendant's expedited motion. During the evidentiary hearing, the court admitted evidence outside the presence of the jury. 5 witnesses gave testimony. Santa Fe Sheriff's Office crime scene technician Marissa Popple, SFSO Corporal Alexandria Hancock, Seth Kenny, SFSO Lieutenant Brian Brandel, and Special Prosecutor Carrie Morrissey. Oh my goodness. If you missed Special Prosecutor Carrie Morrissey taking the stand in the, I wanted to say in the heat of passion, but she was quite passionate. That phrase is normally used for a different scenario. She was angry when she took the stand, snapping, making poor decisions, including her decision to take the stand was a poor decision. You have to go back and rewatch that. At the conclusion of that hearing, the court granted defendant's expedited motion and verbally explained its reasoning. The court enters the instant order in accordance with and in furtherance of the court's verbal ruling. So here we have, this is the receipts. This is the paper backup of the court's order, which was the motion to dismiss. Factual background. On July 9th, 2024, a Santa Fe County grand jury charged defendant Baldwin with 2 alternative counts of involuntary manslaughter in connection with October 21st death of Miss Helena Hutchins. On February 26th, the court entered a scheduling order, inter alia. The scheduling order ordered the parties to make their respective discovery disclosures within the time frame set forth in the rules. The scheduling order, right there on the 26th of February, further, the court scheduling order provides following initial discovery disclosures. The parties have a continuing duty to disclose and make available, this is important, a continuing duty, make available supplemental discovery within 7, that's this many right here, that's 5 and 2, 7 days of the receipt of such information. I'm glad I could help you guys with the math, because that was an easy one for me. Pretrial litigation says, during pretrial litigation of this case, defendant Baldwin filed 4 motions concerning allegations that the state had failed to comply with the court's scheduling order. Sounds like Young Thug. And other discovery requirements established by law. First, on June 24th, filed a motion related to Brady and state disclosure of violations related to the firearm. This motion concerned late disclosures made by the state relating to expert witness reports, statements by expert witnesses. These reports and statements bore on the functionality of the firearm that discharged the bullet that killed Miss Hutchins. The court found the state had culpably made late disclosures. The court denied the motion on grounds the defendant had not established materiality or prejudice as defined in relevant case law. So it's like, yeah, they're late, but it didn't cause you any harm. In distillation, so boil it down to just the pertinent facts. The court reasoned that defendant was now aware of and able to use the late disclosed discovery in preparation for and during his trial. So it's like, well, now you can use it. You've got it. You've got time to prepare. We're not gonna throw it out, and we're not gonna throw out the case because of this. So there was an order entered to deny the motion. Second, June 24th, another motion citing the same thing: Brady and state disclosure violations related to non-firearm discovery. This is other stuff. This concerned thousands of files, including over 150,000 pages of documents and dozens of gigabytes worth of data. Dozens of gigabytes. That's not the 14 terabytes that we just heard about in the other trial. But June 24th, Baldwin's expedited motion for relief for states Brady and state law disclosure violations related to non-firearm discovery. Again, the court found the state had culpably made late disclosures. That's the second time the court says, yep, you're late. You're past that 7-day window. The court denied this motion on grounds similar to those of the previously addressed motion. Nonetheless, in doing so, the court acknowledged the prosecution's representation that the state conducted a complete audit of its discovery disclosure files as soon as it was aware that potential problems existed and has cured, this is important, has cured any disclosure issues. Judge, when we noticed this problem, we went through all our documents and just double-checked. Fine-tooth comb, checked and double-checked, dotted the I's, crossed the T's, we fixed it. No more problems. That was number 2. Okay? Third. And that was July 3rd order. On June 26th, there's another one filed. Motion to compel disclosure and impose sanctions. The motion concerned late disclosures made by the state in relation to expert witness statements, and also asserted that discovery issues related to witness statements remained ongoing in the days leading up to trial. Defendant's reply additionally claimed that between June 27th and 29th, however, Special Prosecutor Erlinda Johnson, a former federal prosecutor, disclosed over 1,100 pages of documents that Morrissey had previously refused to provide. This is Miss Johnson. The same Miss Johnson who quit mid-trial. That's how they got those documents. 1,100 pages that Morrissey had refused to provide. July 5th, 2024, defense Alec Baldwin's reply in further support of motion to compel disclosure and impose sanctions. The court verbally denied the motion on July 8th after parties represented they could conduct a meet and confer to resolve the motion. It's like, let's talk it over. I imagine if we just get in the same room, everyone bring your books, let's double check, make sure we have it all. And the court says, if you're going to do that, okay, we'll dismiss. That's good. Somebody just stuck an arm in my room. I reached around the door and showed me a popsicle. It's a creamy. It's an orange creamy. I have not had a creamy in 5 years, and they're delicious. They're made here locally. And now I'm thinking about creamies. Fourth time. June 27th, defendant filed a motion to exclude the opinions of Lucien and Michael Haig. You know who they were? The Haig family, father and son. That's the two gun expert guys, I think. Were they gun experts? I think they were gun experts. They're expert witnesses that always talk about each other. It's like my dad and I and my son and I did this. One contested, the court denied the motion on the basis that one contested disclosure was not late, and the arguments addressing the other disclosures duplicated arguments set forth in a previously filed motion. Like we've seen it before, and technically this one's not late. It was right on the 7th day. Ultimately, defendant's filings discussed above demonstrate the state continually made late disclosures to defendant throughout the pretrial litigation. There were 4 times that they pretty much had done something wrong, even leading up to the trial. Nevertheless, on July 1st, the state filed a certificate of compliance. Okay, this is when you make a fancy certificate you can hang on the wall, a lot like the internet ownership certificate. It's got your seal, it's got your signature, it's got the name and the date, all that. It looks really good. But their certificate said, "We hereby certify as officers of the court, and under whose hand is now signed," I don't know, they use some flowery language, "that we have complied with the judge's order, and that we have transmitted to counsel for defendant pursuant to the provisions of the rule all materials and documents in a possession enumerated in the previous rule for disclosure by the state." That's, Judge, we're done. We've checked it. We have done. They have everything. Only they didn't. Jury selection. Got days 1 and 2 of trial. On trial days 1 and 2. The court impaneled and swore 12 jurors along with 4 alternates. On July 10th, the parties made opening statements. 4 witnesses gave testimony. You've got Nicholas LaFleur from SFPD. You've got SFSO Lieutenant Timoteo Benavides. You've got SFSO Deputy Joseph Lujan. And SFSO Crime Scene Tech Marissa Popple. We have a spam call. Hang on. Hello? Hello?
Hello?
Sarah? Hello? Hello, Sarah? Are you there? They knew it was me. They hung up. Oh. I'm literally reading a court document. You want to give me a popsicle? Do you know what that will do? I'll make my tongue numb, and I'll get popsicle all over the microphone. Hang on. No. You can. These are the best popsicles known to man. They're called creamies. Chocolate, banana, and orange, and I can't have any of them right now because I'm talking to y'all. Stick them in the freezer. Don't eat them all. Any chance on lunch? I took lunch and I went out to the kitchen and there was no food because they're at the store buying it. All right. So we've got Popple. The court admitted numerous exhibits into evidence on July 10th. On July 11th, Popple continued her testimony in the presence of the jury relevant to this order. On cross-examination, defense asked Popple about ammunition submitted to SFSO by a Good Samaritan near the conclusion of the trial of State v. Hannah Gutierrez. Mr. Shapiro, and a Good Samaritan walked to the police station and gave you the lethal ammunition, didn't they? Ms. Popple says, after the Hannah Gutierrez trial, there was an individual that came to the police station and they stated they had ammunition. Mr. Shapiro said, and they turned in the ammunition? Ms. Popple says, yes. Mr. Shapiro says, and they gave it to you, right? Ms. Popple says, yes. Defense questioning further intimated that these rounds were related to the Rust investigation. Mr. Spiro says, and they told you that this was the ammunition that ended up with Seth Kenny and that killed Miss Hutchins, right? Ms. Popple says, I do not recall all their statements. Mr. Spiro says, okay, but you didn't, he told you it had to do with the Rust shooting, correct? Ms. Popple says, yes. Defense cross-examination further elicited testimony that the SFSO inventoried the ammunition, and a supplemental report concerning the circumstances of the collection of the ammunition in a non-rust investigation case number. Mr. Spiro says, I'm asking you, isn't it the case that law enforcement likely has the matching rounds to the ammunition that killed Miss Hutchins? Ms. Popple says, I do not know. Mr. Spiro says, and you do not know because you made a doc report about this and did not put it with the rest of the rust evidence, correct? Ms. Popple says, those rounds were not placed with the rest of the rust evidence, correct? Mr. Spiro says, nor were they sent to the FBI for testing with the rust evidence, were they? Ms. Popple says, no, they were not. Defense further elicited testimony from Popple, establishing that defendant was not given the opportunity to inspect the newly collected ammunition when defendant inspected ammunition inventoried under the rust investigation case number. They got to see all the rest of the rounds, all the I think the live rounds, the dummy rounds, everything, the spent casings. They got to see everything, but they didn't get to see this. Mr. Spiro says, are you aware of whether the sheriff's office ever informed the defense that a Good Samaritan came in and turned to this ammunition? Ms. Popple says, I do not know. Mr. Spiro says, when the defense came to view the Starline brass nickel primer live ammunition with you, you didn't show them this, did you? Ms. Popple says, I did not have an evidence viewing with the defense. That was my coworker. Mr. Spiro says, your coworker didn't show this to the defense, correct? Ms. Popple, I do not know. Mr. Spiro says, do you have any reason to believe your coworker showed this to the defense, given that it wasn't put in the same inventory as the rust case? Ms. Popple finally says no. On redirect, the prosecution identified the Good Samaritan as Troy Teskey, a close friend of the Hannigan-Tiras' father, Thel. In an effort to rebut defense's cross-examination, Special Prosecutor Morrissey elicited the following testimony from CST Popple. This is where it gets juicy. Ms. Morrissey says, and let me ask you, Ms. Popple, that the ammunition, the Good Samaritan, Mr. Teskey, the close friend of Hannigan-Tiras' dad, that ammunition that he brought to you after her conviction, you still have it? Ms. Popple says, yes. Ms. Morrissey says, you can bring it here and you can show it to the jury, right? Ms. Popple says, yes. Ms. Morrissey, and they can see for themselves that it does not match the live ammunition for the set of rust, correct? Ms. Popple says, yes. And that is obvious just when you look at it, is it not? Ms. Popple says, yes. Following, this is, the problem is she's looking at, the ammunition that Teskey brought was mixed, and she looked at one picture and just made these decisions. Following CST Popple's testimony, the defense alerted the court of their intention to file a motion regarding the state's failure to disclose to defendant the supplemental report and make available the Teskey-supplied ammunition for review by defendant. Thereafter, the jury heard testimony from two additional witnesses, Alessandro Pieta, who was the maker of the firearm, great guy, SFSO Corporal Alexander Hancock. The court recessed the jury for the day amidst the state's direct examination of Corporal Hancock. Jury day 3, expedited motion hearing. On July 12th, outside the presence of the jury, the court considered initial argument by the parties of the defendant's expedited motion. Defense argument primarily focused on the state's failure to disclose the supplemental report and lack of opportunity to inspect the Teskey-supplied ammunition. The state's arguments primarily focused on the purported provenance of the Teskey-supplied ammunition. Special Prosecutor Morrissey proffered, Mr. Teskey is Thel Reed's close friend, and Mr. Teskey stores Mr. Reed's ammunition. Mr. Teskey is a retired police officer who has a whole bunch of security at his property. So Thel Reed has 300 rounds of live 45 caliber ammunition, and he and Seth Kinney are hired by the producers for the show 1883. Special Prosecutor continues. So they get hired to do what's called a cowboy training on the set of 1883. So the company training is where the gun experts, that being Thel Reed and Seth Kinney, take the actors to shoot real guns with real ammunition. Further, Special Prosecutor states, when they originally went to the cowboy training camp in Texas, they didn't take all of Thel's ammunition. They took a certain amount of it, and Thel left some in Troy Teskey's garage. All of this ammunition came from the same place. This was all from basically the same batch of ammunition that Thel Reed had got from an ammunition manufacturer in Kingman, Arizona named Joe Swanson. Morrissey elaborated that Thel Reed and Seth Kinney take 300 of his rounds. They go to the cowboy training camp. Then Seth Kinney takes the leftover rounds back to PDQ. This means that basically the live rounds went through PDQ is what I'm hearing here. With respect to the Teskey-supplied ammunition, the prosecutor further explained that during the initial investigation of the rust incident, Mr. Teskey sent to Seth Kinney a photograph of a sample of the ammunition in Mr. Teskey's possession. That photograph was sent to Corporal Hancock and Special Prosecutor Morrissey. The prosecutor proffered, when you look at that photograph, I'll blow it up for you. You can tell these are not similar rounds to live rounds that were found on the set of rust. This gets funny because she's like, this is, you could tell it's not right. These are brass. They're not nickel primer, but they were a picture of a couple of them, not all of them. She says not a match. When you look at it, we're not going to do any testing. We're going to skip a little bit because this is a long document. We're not going to read the entire thing. The prosecutor offered additional conclusions regarding the Teskey supplied ammunition. She says there was absolutely nothing about the ammunition that Troy Teskey had that has any evidentiary value in the Gutierrez case. It has no evidentiary value in the Baldwin case. Ooh, salad has arrived with strawberries. I'll have you know, with strawberries. Look at that. I'll just set it right here on all my expensive gear. Finally, none of this is exculpatory at all. This is the exact same batch of ammunition that has already been sent to the FBI and tested because it all came from the same place. There's no reason for us to do it again. Court ordered that Teskey supplied ammunition be produced for inspection, as well as previously undisclosed supplemental report prepared in connection with the collection. This is when the judge put on the gloves, steps down, and starts looking at it herself. Turns out there was a match. Let me go down through. I want to see we're going to get through the preliminary. The judge found that it matched, and she was mad. Analysis and ruling. Overview of law pertaining to Brady violations. In New Mexico, an assertion of a Brady violation is an allegation of prosecutorial misconduct. This is huge. In order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and that the evidence was material to the defense. The defendant carries the burden of establishing a Brady violation. Appellate courts review a trial court's ruling on prosecutorial misconduct for abuse of discretion. The first element requires proof that the prosecution suppressed or withheld evidence in question. It does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment evidence or as exculpatory evidence. Evidence is material under Brady only if there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Brady requires us to look at the entire trial to determine whether the defendant's conviction was obtained by violating due process, whether his or her trial was tainted with a fundamental unfairness because certain evidence was not disclosed to the defense. Under New Mexico law, or the application of Brady, while post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, this was not post-trial for Alec. Discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings. That means it could affect Hannah's as well. Overview of law pertaining to discovery violation. Trial courts possess broad discretionary authority to discuss what sanction to impose when a discovery order is violated. Let's see. The assessment of the sanctions depends upon the extent of the government's culpability weighed against the amount of prejudice to the defense. Our case law generally provides that the refusal to comply with the district court's discovery order only rises to the level of exclusion or dismissal, where the state's conduct is especially culpable. It would only reach that if the state was really bad in what they did, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state's intransigence. Intransigence. That's a big word I've never said before. Prejudice may be more than speculative. The party claiming prejudice must prove prejudice. It is not enough to simply assert it. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. A court has the discretion to impose sanctions for the violation of a discovery order that results in prejudice of the opposing party. I just noticed I've got a noise gate on, and that's also bothering me. Oh, that sounds better. Oh, that's so much better. Isn't that great? You probably can't tell the difference, but to me it was clipping off the first millionth of a second of my sounds. And now you get to hear me breathe. Let's see. Trial courts should seek to apply sanctions that affect the evidence at trial and the merits of the case as little as possible. There's a Brady analysis. The court concludes that all three prongs of the test of the Brady analysis were satisfied. Those are the three prongs. And the three prongs were that the prosecution suppressed the evidence. Second was that the evidence was favorable to the accused. And the third was that the evidence is material. So where does that take? Therefore, the court finds and concludes the defendant established a Brady violation, which amounts to prosecutorial misconduct. In New Mexico, an assertion of a Brady violation is prosecutorial misconduct. There's a Harper analysis. Assessment of sanctions depends on the extent of the government's culpability, weighed against the amount of prejudice to the defense. As to culpability, the court finds the state is highly culpable. The state is obligated to timely produce discovery under numerous rules, state and federal case law, and this court's February 26 scheduling order. The state, through the sanctions of sheriff's office agents and Special Prosecutor Morrissey, intentionally and deliberately withheld this evidence from defendant when deciding to place the supplemental report and Teskey supplied ammunition in a non-rust investigation case number. In addition, at least one member of the prosecution team, Ms. Popple, knew of the physical characteristics and the attributes of the Teskey supplied ammunition. She had seen it. She knew that it matched. There's the supplemental report. Any purported mistaken belief by Morrissey as to the physical characteristics of the collected ammunition, due to at least a lack of reasonable diligence, is no excuse for the state's suppression of evidence. Information within the custody of police officers or other persons who are part of the prosecution team was presumed to be within the control of the prosecution. So if one of your team did it, it counts as if you did it. The knowledge of the members of the state's prosecution team is imputed on the state. Therefore, the court finds and concludes that the state's level of culpability rises to the level of willful and deliberate misconduct. As to prejudice, the court concludes that the defendant has established that he is prejudiced by the late disclosures and coterminous. There's another word I've never heard before. This judge has a huge vocabulary. Coterminous discovery of order violations. Specifically, defendant established that the evidence is material, the defense closure is late, and it undermines the defendant's preparation for trial. As also discussed above, the evidence is material in that the Teskey supplied ammunition relates to the two most critical items in the case from an evidentiary perspective, the firearm and the live ammunition from the set. The defendant was prejudiced by the state's disclosures. Given the court's assessment of culpability and prejudice, the court concludes the extraordinary sanction of dismissal with prejudice is justified under the rubric of Harper and the additional guidance of Lemire. Dismissal with prejudice is appropriate for several reasons. First, the state repeatedly failed to fulfill its discovery obligations during pretrial litigation of this case. Second, the state's suppression of the Teskey supplied ammunition and related evidence constitutes willful and deliberate misconduct. And third, Special Prosecutor Morrissey elicited false testimony from CST Popple on July 11th in the presence of the jury. Fourth, a mistrial in this case would not be based upon manifest necessity and jeopardy had attached well before information concerning the non-disclosure came to light. When a court declares mistrial, manifest necessity must be the bias. Here, the mistrial would be based solely on the state's discovery violations, the intentional suppression of the aforementioned evidence. In this circumstance, a sua sponte declaration of mistrial is improper. A grant of mistrial is not proper merely to allow the state to strengthen its case at a subsequent trial or to secure an attendance of witness which it's selected to subpoena or to have present at trial. They're saying it wouldn't be okay for the judge to just declare a mistrial and start over, because then the state gets another shot with a strengthened case. Nor is mistrial properly grounded upon manifest necessity where the state has acted in bad faith in seeking the mistrial. Fifth, the lesser sanctions such as, why is that not scrolling? There we go. Such as adverse inference instruction, monetary sanctions, continuance, or reprimand could not cure the fundamental unfairness of the state's misconduct, and its reverberations in trial had infused into the proceeding. You can't fine a way back into, fine by FINE, charge money of the prosecutor, enough to get Alec back to a fair trial. You can't undo this damage. It's already hindered his case. And you getting another bite at the apple after already hindering his case and now being wiser and more, more informed, that would also be unfair to Alec Baldwin. She's laying out the necessity of why it had to be dismissed with prejudice. Given the state's egregious discovery violations constituting misconduct and the false testimony elicited during trial, dismissal with prejudice is the appropriate remedy. It is the court's inherent power to do that, and to talk about that a little bit. The state's discovery violations injected a needless, incurable delay into the jury trial. Further, the state elicited false testimony from a state witness. Dismissal with prejudice pursuant to the court's inherent power. It's additionally warranted to ensure the integrity of the judicial system and the efficient administration of justice. Therefore, the order is granted for dismissal with that. It is therefore ordered that defendant Alec Baldwin's expedited motion for dismissal on sanctions under Brady Giglio and Rule 5-501 is hereby granted. It is further ordered that the above captioned case is hereby dismissed with prejudice. And there's Judge Somner's signature. Spicy. Were that the only spicy thing happening? Oh man, the salad looks so good. I've got croutons, iceberg lettuce. I think I've got Italian dressing as well. Also in the Young Thug trial during lunch, the judge put Miss Love, Prosecutor Love, on the hot seat, asking her questions as to why she was late in disclosing things that she had not disclosed yet. And she struggled to find words. And in the end, the judge gave her an easy out, saying, oh, is it just because you're disorganized? Oh, okay. But this is the last time. Everyone was pretty upset, saying, Judge, this is the first time for you that they've said this. But we've heard this same argument from Prosecutor Love over and over and over throughout this trial. The judge may actually revisit the decision she made, and that might become spicy as well. Let's see. I don't need this anymore. Let's see. Can we jump to... I don't see anything... I haven't seen anything from Judge Boyd yet. Our mods might have timed out the wrong people in chat. Remember, Pickles, not politics. We don't do the religion and politics talk on here. We think those are great topics to talk about and encourage you to do that in another format where it's a little easier to have a conversation and be understood. Let's see. Let me go back to... Oh, I need to be on live. That's why it's not working. Let's go back to Judge Cedric Simpson for a bit, if you can, because I'm going to eat a salad while we're watching. Do we have sound? Or we're waiting? Hey, who's this guy? James Wilton. Land of the Rising Sun. It's framed perfectly for him. Andre Thomas. I don't know who I'm covering up. Heather Burton. Just waiting for Judge. What time is it? Oh, we should be starting in just a couple minutes. And then I can eat a salad. Those croutons are super crunchy. Okay, I'm going to try to get our chat back on screen so I can see that. Oh, he's on recess till 3 p.m. Central. Till 3? Are you sure, Frosty Jen? 3 p.m. 3 Eastern? Normally he shuts down a live stream if he's off for 2 hours or more. Oh, wow, look at this. Angie, fast 19 months. Never boring. Thanks for the good times, Ari. Thank you. And one of our OGs, Angie, the OG is for G. 19 months. Thank you very much, Ann. It's wonderful still having you here as one of the originals.
I'm just nervous. Don't go far.
Heather, we can hear you.
Check, we're good. Just
tech support is on standby.
Okay, so it looks like they didn't start yet.
Shara's gifted 5 memberships. Thank you very much, Shara's. Very generous.
Court will start, it said. What?
Court is saying we can hear you. Alley Cat member for 12 months says, don't forget to hit the like button. Thank you very much, Alley Cat. Congratulations on the Orange Courthouse. Indy Cindy, member for 14 months. Glad to see everyone today and hope all is well. All is well. It's good. I have a pillow. I'm sitting on a pillow now because I think the seat cushion on this imitation Lazy Boy chair is made out of rebar. Shara's gifted the 5 memberships, and then Angie came in with a 19-month membership anniversary. Thank you very much, Ann. I almost started the live stream this morning with the police chase from a couple days ago. I have not read the new Maya docs. I have not heard where we're at. I've sort of lost track of that case. It hasn't been on top of the radar. There's been a lot of other things happening. Let's see. Andre is at work. He must be on break. Weather watch. For those who watched the live stream of us driving across the country, we did have a check engine light that came on in, I think it was in Iowa. And Weather Watch texted me directly because he has my number, and he said, "Bet it's your O2 sensor." He says, and not only does that, he also goes out, he Googles, he knows my route that I'm traveling, Googles the route, finds a stop that we'll be passing, finds a shop that will read the codes for free and is not out of the way, and he's like, gives us everything. Here's the address, here's the location, you're headed there next, stop, they'll read the codes and tell you for sure. And he says, I bet it's an O2 sensor. And I bet the code starts with this letter and this number. Sure enough, like check. It was the O2 sensor. I would have changed it like right there in the parking lot, but for some reason they said they wouldn't let me use their ratchet set. I could borrow for free the custom special socket I would need to pull the part out, but I would need to supply my own ratchet set. Well, in my wisdom, I left my ratchet set at home. And so I decided I'm not going to purchase another ratchet set because I don't need 2. I barely use 1. But yes, we need to get that fixed. I think we're going to do that here in the next day or 2. The only problem is that it does impact our gas mileage a little bit, but that's about it right now. And there's a little light on the dash. Lizzie Dog, by the way, Weather Watch, thank you very much. 19 months OG as well. Lizzie Dog, member for 15 months, says, well, enjoy your office away from your office. Oh, and that vacation. It's beautiful. I'm loving it. I can see it. I can see the outdoors. It's almost like I'm there. There are the mountains, wind blowing through the trees. Let's see if there's anyone. Let's see if there's anybody out in the park that we can spy on. Nope. Volleyball courts are empty. Basketball courts are empty. The lawn's newly clipped. They just mowed the thing. You can still see the tracks from the lawnmower, see? So we'll go back up. We'll go back up there and check out the mountains because they're pretty. All right, back to Judge Simpson. Thank you, Lizzie Dog. The vacation is wonderful. I'm loving it already. The kids are having a blast. I think they're going to go swimming here today or tomorrow. Green pen. Green pen. Not red pen, but green pen. I see what you did here. I don't know if this is red pen or somebody else. It says, for the You Need a Ring Light, You're Too Backlit Fund. Okay. I have a table lamp. A table lamp that I'm using right now. And it's not the best, but it's working. It was in Nebraska the light came on. Are you trying to say you now have a bony bum? No, I have more than enough padding to go around. A lot of weather going on. This house on high ground, and our house has never flooded in the last 100 years that they've kept records on the town. We've had some pretty significant storms in that time. So our house has never, but that doesn't necessarily mean our basement has never flooded. And that's what I'm worried about, is the basement flooding. Trying to connect. That call dropped. Not sure why. Our house is on high ground. I think we sit above about 60 feet above sea level. That's high for the area. I'm on the East Coast. Adam says, I waited by Highway 70 for 4 hours, hoping to get my internet owner certificate signed by you and Mrs. R.A. We honked the entire way so that anyone who was nearby would see us go by. Did you hear a car go by honking? A big Yukon XL? That was us. We've landed in Layton, north in the Wasatch Front. Oh, Greeners. Greeners comes in with Adam. You actually have to win the internet first. Wow. Hey, Mrs. R.A.'s here. Where's she? We watched for you. Where were you? Yeah, we watched out the window the entire time. Ring light fund for R.A. Here's the problem. I don't have room to take a ring light home. Seriously, because I already know that between Mrs. R.A. and us, Mrs. R.A. and I, one of us is already going to be purchasing things here that we need to bring home. And we don't have room for that. And so I'm pretty sure I don't have room for a ring light. I'd have to give it away to somebody before I left. Have you seen anyone in our chat that lives close where you have your Airbnb? Mary, no, we wouldn't invite somebody to the Airbnb, just like we don't invite people to the home. But we will probably bump into some people up at the trial on Friday up in Park City. We're going to be at Corey Richan's hearing. It's a short hearing, so I'm not sure. It's not an all-day hearing. I will be back up there in Park City. I think it's the 26th, 27th, and 28th. Those 3 days for a much longer hearing for Corey Richan's. And we'll probably bump into a few people then as well, which is going to be awesome. Zachary Wells gifted 5 memberships. Thank you, my friend. Super, super generous, Zachary. It's great to have you here. And many people owe you for the fact that they can now chat unrestricted without slow mode and have a green name and chat with a courthouse by their name. So thank you, Zachary. Also buy a trailer to carry the ring light and other stuff. Send stuff home via UPS. The problem is it would arrive before us, then it would just get stolen because we're driving, and UPS is faster than me. We confused Illinois with Indiana. I still would not be able to find either of them on the map without letters on the states. What time is Corey Richan's on Friday? I think it's at 1 o'clock. I think it's a 1 o'clock start, which means it's going to be a short one. High school is in the next town before Layton. Clearfield? Kaysville? We came down through Weber Canyon. So we sort of came through sort of South Weber area. We are geographically impaired? Yes, we are. Mrs. R.A., I'm going to own up to that. Okay, Cedric was live 30 minutes ago. Hopefully that's clear as mud. Zachary, thank you. Thank you so much. Appreciate the kind words. All right. I don't know. We might meet up at a park or something. I don't know. Don't do this. Mrs. R.E. can see it. She already bought the popsicles. Thank you very much, Holly Mac. And then we followed up with the K-Mat Red Queen shipping things home fund. Let's see. What is the family doing while you're working? What they're doing today? Today is basically a down day from recovering from sitting on our butts. I know for me, I'm sitting on my butt to recover, but we sat in the car for 4 days straight, just driving. We did stop and get up and walk every 2 hours or so. Stop at a lot of different sites along the way. Some history sites. We went to Walt Disney's family farm, which was awesome. That was, I mean, it's a tiny little thing. It's got like 5 parking spaces. It should be massive. It's where he had his dreaming tree, where he sat under and thought up a lot of the stories. It was cool to go there. But now what they're doing, they're going to be visiting. They're going to be going to some museums. They're going to just a lot. We've got family on my wife's side. A lot of them have moved from Idaho down to various parts of the state. We're going to be seeing some of them. We're just doing a lot of activities. Mrs. RA, ship Uber RA funds so she can carry all her goodies in the car. Ship me via Uber. Do you know how much that would cost? Shipping things home fund. Oh, my goodness. They're enjoying the hotel and the food. Judge Boyd's jury. We're watching for that. If you see the jury come back, let me know. We're going to jump and watch that live. Miss RA, could you come talk to us so RA can eat his salad? Guess what I brought? I brought another set of headphones, and I brought Mrs. RA's mic. So we have 2 mics. She could probably even sit over there on the couch if I were to clean up the couch, like if I were to move all the wires. If I were to do that, doors opening. I have to clean really quickly, guys. We're waiting for court to start so I can eat my salad. Mrs. RA is here. Hey, wave.
Get me off the screen.
Now she's leaving. Now she's leaving. She's not going to talk anymore. She said, get me off the screen, and then she walked away. Now I'm in trouble. All right. Pull her video Monday and play it. It was great to watch her with the new defense attorney. We watched that, Jackie. We watched her Monday video where she ripped the new defense attorney apart. I got canceled by Mrs. RA. Wendy, congratulations on the gifted membership. I want to see what James Archer Wilton has to say. He seems happy to be here. I'm not sure who he's talking to. We can't hear him. Is there any audio? No audio. She could see the screen, so she saw she was on it. On the docket, what's coming up? Corey Richard's hearing. We're going to be in person for that one up in Park City. That's on Friday. We have Robert Tullis in, I think it's Las Vegas. That's jury selection starts on Monday. That's coming up. That's our new big trial we're going to be following. We have a little bit of Cedric Simpson. We're going to be watching a little bit of Judge Boyd as we're waiting for the sentencing decision from the jury. And RA positioned his camera 157 times. I moved it during lunch. I did. Melissa says, hi, Scott. Hi, mods. Hi, chat. Melissa, thank you very much. 7 months. Appreciate your support. Oh, the beard has to go. It's getting in the way of eating, and that's when I trim it. And that's when it goes. I actually asked Mrs. RA, because I forgot my razor. So I'm looking like, I don't know, ZZ Top right now. And it itches like I'll get out. I mean, it tickles. It's too long. The beard's going to go here really quick. Do you see Kari's response to Hannah? No. I haven't looked at that one. Oh, Andre's got some bling. He's repping the bling. I think James is a sovereign citizen. That would be funny. Is it spicy? She's got beautiful hair. Looks good. I'm just impressed she has good lighting. So often we have poor lighting. Like, I have very poor lighting. She has better lighting than me, and she's like appearing for court. Andre is on the run. Bench warrant to follow. Is it luscious hair? No, I'm not going there. Nope. Let me see if there's anything else we can see. In the world of true crime. Where did our Sovsit guy go? He was talking for a bit and then disappeared. Is EDB? Is it tomorrow? Is Corey Richards tomorrow? If it's tomorrow, we're going to be there tomorrow. Now I need to look it up. Hold tight for a minute. This is Summit County. Current court dockets. It's going to be Justice Courts. No, it's District Court, I think. Proceed to site. August 8th. Okay. Yes, it is tomorrow. Corey Richards, 1:30 p.m. Motion hearing before Richard Mrazek. Case involves domestic violence, aggravated murder, attempted criminal homicide, distribute or offer or arrange distribution of controlled substance, twice, mortgage fraud, false fraudulent insurance claim, forgeries. Yeah, this is the right case. So that's going to be, I think it's in courtroom B, 1:30 p.m. for a motion hearing. If I had a printer, I would print that out. Instead, I'm just going to download. Save that. Okay, so we'll be there tomorrow. Does that work? I said it was Friday, but I was completely wrong. Let's see. Dottie Forgotti says, I like the old setup. Why the change? I'm about 2,000 miles away from my old setup. That's why. We brought all the gear with us, but not the house. We're on vacation for about a month, so we've set up a temporary studio on our vacation home. At our vacation. I call it vacation home. We rented an Airbnb. It's a workation. Okay, Karen Reed is Friday. That's right. Karen Reed Friday. Corey Richards, the other KR case on Thursday. I'll be up there. We'll go up. I guess we're headed to Park City tomorrow, guys. That's great. There's another lawnmower. Why are they mowing the lawn again? Okay. Ashley says, thanks for bringing us with you. A lot of us were wandering or lost for 2 days. It was quiet in court those days, right? Not a lot happening. We do have, also we've got the podcast tomorrow night, which is going to be a lot of fun because we didn't get one last week. Brandy was streaming. That's awesome. I'll get R&R on the weekends. That'll be good. I'm curious what Andre Thomas's hat is. Is that like bling on his hat? Is that a hat pin or is that a patch? Ooh, live SWAT team standoff. Deputy shot. Halston City, Texas. Don't mix up the time zones. Oh, time zones I'm already messed up on. I'm so mixed up on times it's not funny. Okay, we're going to be at Corey Richards in Park City tomorrow. My plan is to stream that to Top Mark Media. And possibly, if I can figure out how to do it tonight, remotely log in to my Mac Studio here and push it live to Recovery Addict channel as well. Use UTC. Then nobody would know what we're talking about. So we can watch Boone and Reed on Friday. Yes, Boone is in the morning. Reed is also probably in the morning, probably at the same time. Oh my goodness, an hour from your house, Helena? Where's my... Let me get rid of this one. Let's see if we can find Fox 4. So just a quick peek at Fox 4, if you give us a minute here. They're showing an ambulance. It looks like it's headed to a hospital, possibly with a deputy that was shot there. Standoff down there happening now. But that's not cool. That's not something that I endorse at all. But we'll keep an eye on that to see how that develops. Got called into my boss's office for a meeting for a couple of hours. Lindsay, you need a new boss. Reads in the afternoon. That would make it better. Sarah Boone in the morning, read in the afternoon. Digital string theory. I'm just glad to be in the same time zone. We are now. Suspect was injured. Suspect's in custody. Maybe the suspect's in that ambulance. Josh, let's take a look. Oh, Judge is coming back. Cedric's back.
Be seated. Scanning the room. None of them are missed out. Court does call the case. People versus Heather Burton.
And David Shan on behalf of Heather Burton, who's appearing via Zoom. Heather, there you go.
Hi.
Hi, Heather.
Did you state your name?
Can you hear me
Hi.
now?
Yes.
Heather Burton, I'm sorry.
Yeah, all right. Thank you. All right. What are we doing, Mr. Shan?
We do have a plea in this matter, Your Honor, in return for the more serious charge of operating while intoxicated being dismissed. My client will plead to operating while visibly impaired.
That is correct, Your Honor. So I moved that count 2 of operating while visibly impaired. You accept the guilty plea to count 1 and dismiss it.
Count 2.
Thank
you. Then you'll dismiss count 1. I got you. All right. Ma'am, can you please raise your right hand?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again, please.
Heather Burton.
All right. Ms. Burton, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes.
And understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand all of that, ma'am?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
On the date of February 10th, 2024, at the location of State Street, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, I did.
You recall what you had and how much?
It was a one drink, but it was a large drink. It was like it was a 16 to 20 ounce drink. And then I had a shot, but I know there was more than one shot in that drink.
Okay. Were you stopped by the police or was there an accident?
I was stopped.
Okay, why'd they stop you?
I was intoxicated. I'm sure I was swerving.
Okay, so some type of erratic driving.
Yes, sir.
And you're not disputing the right or challenging the right of the police to stop you in this case, are you?
No, sir.
All right. Were you arrested?
Yes, I was.
And were you taken to the police station or a hospital?
Both.
All right. Was there a blood draw?
Yes.
All right.
Your Honor, the results were 0.168.
0.68. All right. Ma'am, do you have any reason to dispute those blood test results?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Absolutely.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes.
The defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be September 11th, 2024, 9 a.m. or as your invite indicates. Defendant's bond with its conditions will continue. And ma'am, I just ask you to hang on the line. What we're going to do is we're going to put you into a breakout room with our probation intake so we can start the process, okay?
Thank you so much.
All right, thank you.
Have a good day.
Mr. Shan.
Thank you, Your Honor. Thank your staff for allowing us to appear via Zoom.
Oh, they did this?
They did this. I had a hospital visit yesterday, so they were helping me out.
Yes, they told me, and I hope you're doing well, sir.
Thank you very much.
All right, take care. Court does call the case of the people versus Kevin Stevenson.
Conrad Solar on behalf of Pittsfield Township.
This is called Senator Devlin. I'm attached to who I cannot believe is present unless he is on Zoom.
Kevin Stevenson? He's not here.
I was unable to get in contact with him prior to today. I believe the contact information he had turned was not good. So I do not have an explanation for his failure to appear.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I will give a 10% privilege on that. There having been previous warrants, this warrant will issue immediately. Thank you. Court does call the case of the people versus Andre Thomas.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, this is Public Defender's Law Attorney on behalf of. Can you state your name for the record, please?
Andre Thomas.
Thank you.
Your Honor, Mr. Thomas is trying to get his license back. We would like to request a adjournment.
How close is he or how far is he away from that goal?
Mr. Thomas, can you remind us where you're at in the process?
Your Honor, I had another matter, a couple of tickets out of the 34th and Romulus. I took care of those within the previous last time we were meeting. So now I have the next meeting is for 2 weeks at the Secretary of State. I was in a case with another case that actually was disclosing the information. So I went to court for that case. That case is adjourned. I paid the course fees. So now I'm just waiting for the other appointment to meet with the mother of the boards to actually reinstate my license.
Okay.
So it's a process because I had maybe, Your Honor, to be honest, I had a lot of tickets and I'm working day to day to get them together and pay them and get everything together. It was a probation case that I did finish probation on. So now it's just working to actually get the process rolling. Just wanted to let you know I was being cooperative and doing everything on my end.
Okay. October 2nd, 2024, 9 a.m. All right. Let's see where we can get. Okay, Mr. Thomas?
I appreciate you, Your Honor.
All right. You take care. Thank you.
Thank you. You too.
Court does call the case. People versus Tatiana Teague.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of this Heath was arrested at Community Corrections today.
She was arrested?
Yeah, she had a warrant out of 14B and went to download her calendar and they arrested her. So she called our office.
Miss Perry, this has been a rough day for you.
It's not my turn.
Yeah, no,
She's
I
had a
know,
really
I
rough
know,
day.
but just
So I don't know what's going on over there.
it's okay. You know, tomorrow the sun will shine. It'll be okay.
Tomorrow's not a day.
Yes.
I assume she's being booked right now. So she called us from the jail.
Oh, she did?
Informing us that she's arrested. Yeah.
She's got one call and she called you.
You know, the phone's over.
Yeah, I'm kidding. That's all right. All right. So you'd like an adjournment. Okay. We don't. Did she give you an idea, or do you know maybe when her 14B date is? Probably not, because she's going to be arraigned on that and given her day.
Yeah, she had no idea even why she was being arrested.
Sure.
So,
Well, I'll raise our hands as to who believes that.
Yeah.
September 4th, 2024, 9 a.m.
I want to hear James Archer's story.
Court calls the case, People versus Corey Harris.
Conrad Sewell on behalf of Pittsfield Township.
May it please this honorable court, Deion Webster Cox on behalf of Corey Harris. And we have good news.
All right, yeah, I know. Go ahead, I'll let you say it.
My client has his license, Your Honor.
It's fine. He's had it for a while.
Yes, and see, what did we do? We moved forward, focused on the positive, and now here we are. We can proudly stand before this court and say, we did it, okay? We did.
Yes, he did.
Yes, we all did. It was a collaborative effort. So
24 years late, but we did it.
We did it.
We got there.
We're here.
Congratulations, Mr. Harris.
Thank you. Better late than never.
That's right.
Wasn't I saying that at the beginning? I was.
It was. We heard that.
Absolutely.
That's all I wanted. I told you that from the very beginning, Mr. Harris. All I wanted you to get your license.
Exactly.
And
thank you.
I wish it could have.
We saw that.
Thank you.
You're welcome.
You just helped me out speed up the process a little bit faster. Thank you.
You were hard headed though.
Yes, I am.
Yeah, you were hard headed, right?
My mother and my wife tells me this daily.
That you're hard headed?
Yes.
Yes. And you showed it to not only me, but the whole world. That you were hard headed. And all I wanted to do, if you had left that first day, after the first hearing, I revoked your bond. You came here. You followed what I said, and I didn't have, because I didn't really have a problem with you. If after you had left the jail, and if you had just gone to the did what you did, we'd have been done with this long ago. Really.
Instead, he went viral
and
all over the internet.
When it all said and done, that's all I wanted. That is all I wanted. I just needed you to have your license.
He's like, good. Can I
Mission
go now?
accomplished. So.
And it feels good, doesn't it? Mm-hmm. Yeah, it feels good. You're not looking over your shoulder all the time, right?
Exactly.
It's amazing how that works. All right. And I did, not that I'm a social media person because I don't watch social media, but I saw him do his little dance out there in front of the Secretary of State.
That was after his training, after he passed the test.
After he passed the test.
So we
Did
were
Mr. Archer just
documenting
get
the
abducted by
process.
And
aliens?
as long as, and I knew, so like I said on the record, I kind of said it a little quip and a little snarky and probably shouldn't have said it that way. But I knew if he just passed a written test, the driving thing wasn't going to be a problem.
Because you've been
he had been
practicing
doing
for
that
years.
for 24 years. So it didn't, he was going to be able to pass that part. All right. So
So we're,
With the newly vamped Mr. Harris.
Yeah, and we're all happy about that, so I will keep my promise, and if you would like to admit double parking today, you can do that, and if you accept it, Your Honor, I move to dismiss the more serious misdemeanor charge.
we will absolutely admit responsibility to double parking on that faithful.
Which he did not do.
Over.
Mr. Harris.
Double parking. There goes Mr. Archer again. Just yeeted himself off the
Mr.
screen.
Harris, do you admit responsibility to the fact that on October 7th, 2023, location of Ellsworth Road near Laura Road, Pittsfield Township, Washtenaw County, State of Michigan, that you double parked?
Yes.
Satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Okay, but everybody in this room knows he did not double park.
Anything you want to say before I impose fines and costs?
Your Honor, my client has, I'm asking that the fines be as much as this court can, because he and his wife are both out of work, and they've been working diligently trying to find work. But it's just things are financially, the margins are, and as a result, we're just asking that court, in addition to what the court has already done, that.
So after all this, you're asking me to do something nice?
I am. You know I'm going to ask. That's what I do.
Oh. Do I do nice things? I don't. No, I don't. Well, thanks for volunteering that, man. Mr. Harris?
Yes, sir.
Throughout this whole thing, outside of the driver's license, everything else, tell me what you learned.
You need to get this sensor right.
Think makes you a better person now.
What I've learned is just pretty much stay focused, stay on task, and do not look back and just go on out here and just handle things right then and there. And then that way, I don't have to worry about anything crazy later.
That was close enough.
And thank you very, very much for teaching me that hard lesson.
What you gonna do for him, Judge? I learned not to double park. We did have a verdict in the Castro case. We're waiting for the jury to.
One day we'll meet out on the street under better circumstances. Just keep your car in the lane. Don't be running into my truck. All right. So
I'm a very good driver.
I know we have 20 some odd years of you doing that. That's actually pretty good. All right. Fines and costs of $180. Mr. Harris, I don't know why I'm doing this. It is absolutely against my better thought, but I'm going to do it. I'm going to waive the entirety of the 180 and fines and costs.
Thank you.
You're all set.
Thank you.
Probably, Judge, because you got like 75,000
May I take your
subscribers.
hands
I know. I don't think you can touch them.
Why do you say that?
Okay.
Shakes hands with him.
Thank you. All right.
All right. You're welcome.
That's
Just
beautiful.
do the right thing.
That's beautiful.
Okay. Thank you.
Thank you.
He's all over the internet. He will. I mean, this will be his video will live forever in infamy. But he walks out of court, 0 fines, and he has his driver's
That's
license.
all your people around the courtroom waiting for you? Did they think you were going to get locked up again?
My daughter.
That's your daughter.
That's her daughter. This is my wife.
That's your wife. So she came to make sure you didn't get locked up again. She kept you straight.
This guy
All right.
called into a Zoom hearing for driving with no license
That's it.
while driving
Take
a
care.
car.
Court does call the case. People
was-
versus Ebony Woodset.
Yeah, it was amazing.
Conrad Sullivan.
Good afternoon, this is Public Defender Warren Attorney on behalf of Ms. Whitsett.
Oh, okay.
Oh, she's Is she here?
Say your name, please.
Ebony Ritz. Okay.
I wonder if she just
All
did
right.
it.
Where? Anti-violence. All right. Where are we on there?
So, Miss.
Well, hold on. Did she? That's warranted. Okay.
How long do you think she's going to keep her hands out of her pockets?
So she had, yes, keep your hands up. She filled out the warrant recall on one case and tried to do it on both, but I think it was just the technological difficulties, and one made it to Your Honor, and one didn't. So one is still in warrant status, and this other one got reset. So the one in warrant status, I'd ask that you recall the warrants. She is here and trying to take care of things.
Sunglasses,
please,
and a t-shirt. Please.
Why does everyone want me to be nice today? That's so much against my nature. This is really hard.
I will say she was taking care of her granddaughter, her baby granddaughter, and she said that was her explanation for not taking care of her business.
It was.
Oh,
so now they're going to give me a story.
Well, we know how you feel about little babies, you know.
I don't like all little babies.
Well, this one's great, little baby.
Okay. This one you'd like, John. Are you nervous?
Very.
Why?
Huh?
Why?
Well, I'm not nervous. She just got me shook up his story.
Huh?
His story fit my story. So I'm a little emotional. You guys just laugh.
Corey? How does your story fit?
Because I'm battling trying to get my license back.
Okay,
That's
so
what I'm
first
going
of all, here's the deal. You're battling to get your license back.
Right.
Tell you a little secret about Corey.
You know,
Corey was not battling anything for a long time.
Right.
That's where
24
Corey
years.
got in trouble. All right. So anyway.
At least I'm trying.
Okay. Look, here's what I'll do. On case 0079, I will cancel the warrant.
Thank you.
Reset her bond at a PR 5,000. Okay. Now, where do we need to go on both of these cases?
So Ms. Whitsett's eligible for her license September, right?
Yes, ma'am.
So
she's gone through the process with. Why September? What's up? What happened? A suspension?
I've been suspended for a year. So I finally got it to a point where they ready to give them back now. And if I get this one on my record, they're gonna suspend me for another.
I know.
Secretary of State.
I know. Okay. So let's do this. Well,
I just need some time.
I guess I want to make sure when the warrant, is she going to have to clear when the warrant went in this, and I don't know, did they hit her driving record and then?
Does not appear to have a clearance fee in JIS.
Gotcha. What about the other? Yes.
Also does not appear on her license. That's not
Good.
sure why.
Okay. No, that's fine. That puts you in better
why don't they make you pay
shape.
fee to get back?
Okay, so September. When in September?
I think they said the 15th. I called Secretary of State, they said, I think like the 15th.
All right, so let me do this then. I'll adjourn both of these to October 2nd.
Okay.
2024.
So she gets her license back and then they get.
But I'm gonna be on driving probation. That's how I lost my license the first time. I was on probation and didn't know I was on driving probation. And so.
You had a restricted
I
license?
had a
You knew, you just didn't care.
No, I didn't know.
Okay. All right.
If I knew, I
The
would have.
story's changing
All
here.
you have
Hang
to
on.
do is read the letter.
Well, even with your restricted license, we can just try to resolve this one. Okay.
I'm trying to get my restricted license.
Right.
All right, I got a little bit more time in the case, but I'm going to set it for the second so we can touch base, see where you are on it. And if you get it back, then maybe something can be worked out. But
Okay.
Thank you.
That's what I need to get back and forth to work because that's one of my, I gotta keep a job. That's one of my biggest things, keeping a job from my past to now. So they just asked me to keep a job,
okay,
but I gotta get back and forth to work.
gotcha. Okay, let's see what we can do.
Is the new date October 2nd?
October 2nd. Thank you. Court calls the case of the People versus Kewan Williams.
Why is that name familiar?
Conrad Solar on behalf of Pittsfield Township.
Have we seen Kawan Williams before?
Assistant Public Defender Natalie Plate on behalf of Mr. Williams, who should be present via Zoom.
He's looking.
Yes, he is. Mr. Williams? Okay, do you have a camera? I think your camera's on. I think it's blocked. Really?
Judge.
You think he- Okay, Mr. Williams, can you hear me?
Yes.
Okay, there you are. We got you. All right, what are we doing?
Thank you, Your
Calling in
Honor.
from
There is a
his
resolution in
geography
this matter
class.
to which Mr. Williams will be pleading guilty as charged under HIDA.
And given his age, Your Honor, I have consented to that.
Okay. Mr. Williams?
And he's gone.
Yeah, I don't, tell you what, counsel, I don't know if that's gonna work with the connection he had.
Understood your,
Oh,
oh,
well, hold on, he's back. It looks like it's,
There he is.
it looks like it's better.
Stand closer to the internet.
Mr. Williams,
router.
can you hear us? You need to unmute.
Yes,
Can
I
you
can
hear
hear
me?
you. Yes.
All right, stay right there. We don't want to lose the signal. All right?
Okay. Yes.
All right. So he's going to plead guilty as charged under HIDA?
that is correct, Your Honor.
All right, raise your right hand. See if we can get through this. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Short
State your
colloquy
name for the
here.
record.
Kewan Williams.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud under the Pittsfield Township Ordinance. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
You still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor. I'm on probation with 15th District Court.
Okay, were you on probation? Okay, were you on probation with them in April of this year?
Yes, I was.
Okay, I do have to advise you that your entry of a plea in this case could be considered a violation of your probation. You understand that?
Yes, I'm aware of that.
Okay. I also have to make sure that you understand that if it is considered a violation, did he freeze? He did. Yeah, try to shut down his video. That would be fine. But you probably can't. Oh,
And he's gone.
Mr. Williams, can you hear me?
Not anymore.
Yeah.
Okay, we shut your video off, so don't worry about it. Okay?
Oh, okay. Yes.
All right. So you understand that if it is considered a violation of your probation, the other court the 15th District Court could sentence you to the maximum allowable under the other charges. You understand that?
Yes, yes, I do understand that.
Okay, and understanding that you still wish to plead guilty to this charge?
Yes, but I have a few things I wanted to say. If there's
Pardon?
Like to plead guilty with an explanation?
I said I wanted to speak if that was all right.
You want to speak?
Yes.
About what?
Where's the case?
Judge, usually this is a bad idea.
Just involving the story for Walmart.
Okay, well, we'll get to a part where you might be able to speak about it. I've got to get certain things on the record here. But you still wish to plead guilty to this charge?
Yes.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way to get you to plead guilty to this charge?
No.
This should be easier answer.
You're doing this voluntarily and of your own free will?
Kinda, yes.
Kinda.
Pardon?
I said kinda, yes.
Kind of a yes. Oh. Okay.
Yes.
Here's what I'm going to do.
Full stop.
I'm
You
going
need
to
to talk
stop
to your
taking your
lawyer.
plea right now because you have to be doing it for an appropriate reason, and I hear some hesitation in your voice. And so I'm going to let you talk to your attorney. Hold it. No. Sir?
Yes.
I have to make sure of certain things regarding this plea. I'm not convinced of everything I've got to be certain of before accepting your plea. So I'm not going to accept your plea today. I'm going to give you an opportunity to talk with your attorney, make sure all of your questions, your concerns, your worries, whatever that may be, get answered. So I'm going to adjourn this case to September 4th, 2024, 9 a.m. Unless you have really solid internet, I'm going to need you in person.
Yeah, I will have internet. I'm currently on a trip for my son's birthday. He got granted from U of M hospital to go to Disney because he was born early and had some complications. They paid for a weekend trip for him, or a week trip for him. It's just kind of horrible connection here.
You're at Disneyland?
Okay, so you're down in Disney?
Yes.
Oh, okay. Look, get back up here. We'll take the plea on the 4th, if that's what you still want to do. All right?
Apparently the Wi-Fi is crappy in the Magical
I'm
Kingdom.
sure today I just wanted to speak towards it. I just wanted to mention that I wanted to apologize to the story. That's about it. I'm sure.
Well, no.
But
there was something else in terms, sir, in terms of the questions that you were asking. You're not in any trouble with me. I just have to make sure that you have all of your questions answered. And so I'm giving that time for that to happen.
Okay.
September 4th, 9 a.m.
Okay.
Or as your invite indicates. Thank you. Bond continue.
At least he wasn't
Thank you, Ron.
standing in line
Thank
for
you.
a roller coaster, Space Mountain.
Court calls the case. People versus James Wilton.
All right, so on behalf
Hey, it's James. Here we go.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Wilton, who is present via Zoom. Can you please unmute and state your name for the record?
James Archer Wilton Arishow, formerly James Archer Wilton.
All right. Thank you.
Thank you, Your Honor. There is an offer of HIDA in this matter. However, my client wishes to set this for final settlement conference. We would respectfully request the October date.
Jury, final settlement conference will be October
Hold on.
18th.
Hold on.
We had previously discussed November when I was on the phone yesterday.
I don't.
Mr. Wilton, we previously discussed that the judge sets the dates and that I believe the next final settlement conference was sometime in the fall, possibly November. It is actually October, so the judge is giving us the date of October 18th.
Your Honor, I would like to let you know that I do live in Arizona, and I need to make transportation arrangements. And if I can get the maximum amount of time that you would allow for this, it would be extremely helpful.
Well, I get you. So I can do the October date. Okay. October 18th, 2024 at 9 a.m. Jury selection, if necessary, October 21st, 2024 at 8:30 a.m. Both of those proceedings are in person. All right.
Be here.
Bond will continue. Thank you, sir.
Thank you, Your
Thanks,
Honor.
Your Honor.
It's like, what about
People
November?
versus
Nope.
Bonnie Weisner.
Conrad Solar on behalf of Pittsfield Township.
Is that arraignment?
That's got to be you because I don't have any files left. That's how you certainly. Come on up to the podium.
So I actually don't entirely know how this process works. Of course, I've seen court TV and I've been in courtrooms before, but I haven't been in trouble with the law.
All right, slow down a minute. Okay. We'll walk you through
A
it.
little
Now,
nervous.
I can tell. All right. All right. So here's what you do. Take a deep breath, relax a little bit, okay?
All right.
Okay. So first of all, state your name for the record, please.
Where's your attorney?
Bonnie Lynn Wisner.
All right. Okay. So Wisner, you're here on a misdemeanor complaint. Okay. And this, what's happening at this point is what's called the arraignment. And at the arraignment, I'm going to go through it. I'm going to tell you what you're charged with, tell you what the maximum penalties are, make sure you understand all of that. This is not a point at which I'm asking you to either admit anything or anything like that, okay? And then I'm going to have a couple questions for you. Got that?
Yes. May I, will I be able to at least tell you?
Well, hold on.
What and why, or?
Hold on a moment. Okay, and then we'll get to what we can get to.
She
okay,
needs to watch more TV.
Because here's the thing: since you're charged with a criminal offense, I don't want you saying a whole lot to me because anything you say can be used against you.
Okay.
And so I don't want you to fall into that position. Okay.
She needs a lawyer.
Okay.
All right. So what I do is kind of directed at certain things that we got to make sure. Okay. Ma'am, you are before the court on a complaint. Misdemeanor complaint that alleges that on or about March 26, 2024, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle while intoxicated by a controlled substance. You understand the nature of that charge?
Yes, I do.
All right.
I believe I do.
Pardon?
I believe I do. Like I said, I haven't been in this situation.
I get you.
But
do you understand what you're charged with? You're charged with operating while intoxicated by a controlled substance.
Right.
Okay. So you understand what you're charged with?
I do understand.
Hey, hold on. Before you go to the next thing, I'm not asking you whether
yes
or
or no.
not you did it, whether you think you're guilty of. I'm not asking any of that. I just have to make sure that you understand what you're charged with.
I do.
Okay. All right.
I do.
That is a misdemeanor. It's punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could also order community service, your vehicle immobilized, could order you to pay the costs of the prosecution, as well as the cost of any emergency governmental services. You understand the maximum penalties and what the court could do.
The ones that you just explained are what they could do.
What the court could do, yes.
Yeah, I understand.
You understand that? Okay. Now I got a very important question for you. And my first question to you is, do you want to be represented by an attorney to help you through this process?
The judge is nodding. You should nod as well.
I believe that would be best. I'm looking at you. You're looking at me like, yes, it is the best.
It is.
Like I said, I've never been in this position before.
Exactly. That's one of the reasons that an attorney can help you with what the process is and the like, okay? Ms. Pate, this is a public defender case.
Oh, no qualification.
Excuse me, Assistant Defender Natalie Payton, on behalf of Ms. Wissner, we would waive any further reading of the complaint, stand mute, and ask for a pretrial date, please.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea on her behalf. Pretrial in this matter will be adjourned to August 21st, 2024, 9 a.m., or as your invite indicates. All right. Yeah. Okay. So, Mr. Siller, I don't think I see it on the complaint.
It's not, Your Honor, it just says controlled substance. The substance was hydrocodone, no one spiked it in.
Okay.
There's no crash, or she was passed out, in the roadway.
Okay.
She passed out at the wheel in the roadway. No crash.
Okay. So what I will do is I will set the defendant's bond at a $5,000 personal recognizance bond. I'm going to order standard conditions, including no assault behavior or weapons. I'm going to indicate there's to be no use of any alcohol,
Okay.
recreational marijuana, or any illegal drug. You understand that, ma'am?
Yes, I do.
All right. What I am going to...
May I ask a question?
Certainly.
So I'm driving around with a temporary license. They took my license and gave me a paper license.
Correct. It's called a 625G permit, yes.
Okay. I'm just wondering, under what circumstances, or how long it takes to get my normal license back. Because I
don't think you're going to get your normal license back until this is resolved. I think you will have that.
Okay.
That's a short answer to that
But
question.
it says on the, this is what's confusing, is it says on the permit.
77 days or something like that.
I didn't even see that.
Okay.
What I saw was this: you are legally able to drive. Your license was not confiscated, but it was.
Okay. You're able to still legally drive on that permit, on that piece, with that piece of paper.
Right.
Okay.
Okay.
Your physical license was taken.
Yes.
But that did not affect your driving privileges.
Okay.
So you can drive, you have the privilege to drive. You just don't have that license.
Okay, I do have a question for you.
Okay.
Yeah, I'm so sorry.
No, it's okay. It's okay.
I was a victim of domestic violence, and actually, you were one of my only saving graces ever that kept my kids and I in my house, and I thank you. And sorry, I'm trying not to be an emotional mess, but the reason that I was on
Careful here.
any prescription.
Hold on. It's, ma'am, and just listen. It's not that I don't want to hear from you. I just, like I said before, I don't want you to say anything that might incriminate you or could be used against you. And I think that's why Miss Pate was whispering in your ear. I don't want you to say anything about the case at this point. Okay? All right? Probably have a lot to say, but
But I am allowed to drive.
My understanding is that you should be allowed to drive, and I will just double check it. My record indicates that your license is valid, your privilege to drive is valid.
Okay.
with the 625G permit, which is that piece of paper that they gave you.
Oh, okay. So should I obtain a state ID then?
Ma'am, I can't advise you as to anything. I will just say this, because of this last case, you cannot have both. So you can't have a Michigan driver's license and a state ID. So that's a question I'm gonna let counsel answer for you.
I didn't know.
No, it's okay. It's okay. It's okay. There's a lot of things people don't know. And that's probably why you have the questions. But you got a great group of attorneys. Let them answer some of your questions. Okay. That may be part of the problem.
There's an arraignment pre-trial.
When?
August 21st.
On this one?
Yeah.
Okay.
August 21st.
Okay. So
pre-trial.
You got another operating while intoxicated case? You're aware of that?
No, I'm not.
Okay. You said that's at 14.
14 it's an arraignment pre-trial.
Do you have an offense date on that?
April 21st this year.
Okay.
April 21st and March 26th.
Okay. So, ma'am?
I had moved and maybe I didn't get mail. I don't.
That may very well be. I'm just letting you know you have another OWI at 1482, our sister court in Ipsy.
Okay.
That's set for April 21st, or not April 20th, August 21st.
Okay.
Okay. So you might want to, Kelsey may want to check into that. She's got an arraignment and pretrial on that one. Okay. So does that just lists the charge? I can't tell if that's alcohol or drugs.
Correct. Yeah, I can. Well, what's maybe drugs? Yeah, I don't know.
Okay. All right. That's okay. We'll let them deal with that. So just so that your counsel, so you have a context to it, at least what we see. This incident happens end of March, April 21st, the 1481 happens. Okay. So there's some context to it. All right. So no alcohol, recreational marijuana, or any illegal drugs. No, ma'am. What I'm going to also order is that you report over to the Department of Community Corrections for drug testing. Okay. So if you have prescription medications that you're legally entitled to take,
yes,
make sure you have those prescriptions or copy prescriptions with you to give to community corrections.
Or the bottle, is that what you're saying? Or
pardon?
The bottle, or actually have it printed?
They'll tell you what they'll need in exact, okay? But I'm just saying, be prepared, like if you have prescriptions that you're taking, that they may ask for proof that you're on those prescriptions.
Okay.
Okay? So I'm signing that order, and you'll be required to take a test one time per week randomly on any given day that they set. Okay?
Okay.
All right.
What a day, Judge.
That's it. I will see you on the 21st. Oh, well, hold on. I better not set it on the 21st.
Yeah, she already has another date on that. According to the complaint, the other case is hydrocodone.
Same thing. Got it. Yes, thank you.
According to the
Okay.
notes in the case,
So-
the other case is hydrocodone.
I'm going to move this one to the 9th or September 4th. Okay, so you'll come back on September 4th to see me. I don't want to set it to 21st because she's got the arraignment pretrial in Ypsilanti on that day. Okay, and also so council's aware, that case, well, a few days after this one, also involves hydrocodone.
Thank you, guys.
All right. All right. Thank you.
There you go, Judge. What a day. I think that wraps up your docket, right? Nothing else? Oh, you got one more.
Close the case, People versus Deja Ulmer.
Comments on behalf of Pittsburgh Township.
Good afternoon, Your Honor. Alexandria Taylor on behalf of Ms. Ulmer.
Good afternoon. All right. Your name?
Deja Ulmer.
Thank you. All right. What are we doing? This is an arraignment. So as
Your
to the
Honor.
arraignment, counsel,
Stand mute and waive a formal reading.
all right, defendant having waived formal reading, standing mute, the court will enter a not guilty plea on her behalf. You're looking for an adjourned pretrial date?
Yes, Your Honor.
All right, I have August 21st and September 4th, whatever.
September 4th.
Adjourn the pretrial in this matter to September 4th,
Well, she's reading fast.
2024, 9 a.m. or
Attorney
as your
Taylor's eyes are
invite
like-
indicates. As to bond in this case, what is the alleged abuse?
Your Honor, the consent blood draw 186. No crash. However, the defendant was passed out in the driver's seat in the roadway.
Okay. Counsel, anything you want to say regarding bond?
Yes, Your Honor. My client is gainfully employed. She's started attending AA, and that we have sought out an outpatient program for her, which she will be enrolling in. She's had no previous contact with the criminal justice system, and so we're just asking for a personal bond for her.
Defendant's bond will be set in the amount of a $20,000 personal recognizance. I will order standard conditions, including no assaultive behavior or possession or use of any weapons. Do you understand that, ma'am?
Yes.
I'm also going to order there's to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
All right. And I will order that the defendant is to report to the Department of Community Corrections for placement on a sober link testing device. All right. And so that you understand, ma'am, that will require that you blow into that machine 3 times per day.
Okay.
Okay. Within various ranges. So make sure you keep track of that. Anything else?
Ms. Taylor,
No.
I'll email you the complaint and police report tomorrow morning.
Thank you so much, and any video too. Thank you.
All right. Thank you.
Thank you. Have a great day.
Everybody have a good day. Thank you, ma'am. 14A stands adjourned.
14A stands adjourned. There we go. All right. So, Judge.
Hey, hello. I was trying to get.
Okay, hold on. What's your name?
My name is Nathan Rhines. Yeah, I was sitting in here. I didn't know.
What's your name again?
Nathan Rhines.
Thought we were done.
You got him?
Yeah.
Yeah.
RYANS.
Everyone, unpack your bags.
I was supposed to have court earlier.
Hang on a second, sir.
Okay.
What time did you have him at?
He was scheduled at 2 p.m.
Okay, you were set at 2 p.m. We didn't, I think I called it.
He was not present.
And you weren't present at that time.
Bench warrant.
Yeah, I believe I was, but I had the wrong number. I couldn't get on. I recorded and I got back on. The lady just gave me the thing.
Well, we keep track of who shows up. You weren't there. So here's what you're gonna have to do.
No,
Did I issue a hang on? Did I issue a warrant? And it's a PD case?
I was just trying to take care of it.
It's a PD case?
Yes.
All right, you need to contact the public defender's office to get the warrant set aside. And then if it's set aside, then what we'll do is we'll reset your case, okay?
There's no way I can just get it handled right now and pay everything off.
Sir,
Yeah.
you were supposed to be here at 2:00. It is now.
Oh, sorry about that. I thought I had my camera on.
Okay. You need to show up on time, first of all. Secondly, I don't have your file any longer.
Okay. Yes, sir.
So you need to get to your public defender. They know the process to try to get it set aside and reset.
Try not to get pulled over on the way there because
Okay,
you'll get arrested.
Oh, okay. I gave you a 48-hour warrant, so you need to contact the court. So your warrant won't issue for 48 hours. You need to contact the court and get your date reset.
Okay.
Thank you.
Just contact the court 14A.
14A1.
Now he's done. All right. All right. Look at that. It is beautiful outside. Got a little bit of information. I've got some people that are going to be, that want to meet with me that are going to be out of town in like 24 hours. And I haven't seen them for years and years and years. So I need to run and meet with them. And since we only have the one car that needs to have 2 cents from fixed, I think I also need to pick up a rental car to make sure I can get up to Park City tomorrow for the afternoon show. Well, tomorrow for the afternoon hearing of Corey Richins. So we're gonna call it quits here. I was hoping to show you some more lawn. The lawn guys are still out working. Oh, that's a fire hydrant. I thought that was him. Maybe they're all done. Okay. Either way, we're gonna wrap it up for tonight, so I can go get the car sorted out for the Corey Richins hearing, so I can get up there and then get to see some family. So that'd be great. Go play some basketball. I can sneak through the hole in the fence. Go play some b-ball. Funny story. My youngest son, who is just a bundle of energy and ideas, has decided that he likes golfing. Right? Well, I don't golf. We don't golf. But he's just like, man, it's like the only thing I ever wanted to do was golf. I mean, this like this. As soon as he got the idea in his head, he decided that was like his life ambition. And so, as we're trying to minimize packing to the bare minimum of what we need, I mean, like exactly how many outfits do we wear so we can rotate and wash everything. I want I've got like 5 shirts to my name here, and so we're minimizing everything. He's like, I want to bring my golf clubs, because I took him to, we weren't going to, we didn't know if he really wanted to golf or not. So I took him to a little, it's called Play It In Sports, where you can buy and sell used sports gear. We took him there and we got him, I forget what it was, it's like a 9-iron and a driver that were his size. I mean, that are, comfortable for him to use. And the neighbor gave him 1 golf tee, and we got him a couple of golf balls. And he's like, I want to bring my golf stuff. I'm like, there's no way. Look, we are packed so tight. You cannot bring your golf stuff. And he was really, really sad. Well, the naughty little munchkin snuck the golf clubs in and hid them under the seat of the car and has his golf clubs. And now he keeps looking at all this green expanse of the fields behind us and thinks that it must be a golf course, and he needs to go golfing. So I just need him to not hit it towards the house, and we'll be good. We did stop and see the world's largest golf tee on the way here. It's like 30 feet tall. But anyway, we're probably going to do a little bit of golfing. Okay, we got to go. All right, we're going to end it right now. Thank you very much. Let's see if I can find the music. I have music somewhere. It's right there. All right. So from the non-glamorous studio here at, ouch, I just kicked this dresser really hard. And that hurt. From the vacation home, from the master bedroom of the vacation home, Thank you for joining us today. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe to go live again tomorrow morning. Tomorrow, we have Corey Richens. I will be going up to Park City, so we'll probably do a morning show. Then I'm going to head out the door. I'll be up there probably a couple hours early to make sure I get everything done that I need. Can we portal you to tomorrow, says Greeners? What time tomorrow? I'm thinking 9 o'clock Eastern is probably the latest. That puts it at 7 o'clock Mountain. So, all right, I think this is 7 o'clock Mountain. I think that's going to be the earliest I can get up, because I have to kick Mrs. RA out of bed if we're going to use the master bedroom here for the studio. So I think that will work. All right, you guys are amazing. We will see you tomorrow. Corey Richens tomorrow. Super excited to be up there in court. I've got to get the live view configured properly. I've got to get the rental car sorted, and then we're going to go see some family and call it good. So you guys be good to each other. We will see you. We'll see you in the morning. Have a good one. Bye.